Good morning, everyone. It is 10 a.m. on Tuesday, May 13th, and I'd like to call to order the board meeting for the Tennessee Funeral Directors and Embalmers. As we begin the meeting, I'd like to bring to your attention there's a sign-in sheet on the table by the door, and for anyone that would like to make comments about an agenda item, please indicate so by your name as you sign in. Public comments will be accepted near the end of the board meeting. Ms. Bohannon, would you please call the roll?
Don Haynes. Here. Chris Lee.
Here.
Randy Nash. Here. Wendell Naylor. Scotty Porsche. Pam Stevens. Tim Willer. Here. Mr. President, we have a quorum.
Thank you, Ms. Lisa. First on the agenda, I'll accept a motion to adopt the agenda for today's meeting.
So moved.
Second.
Have a motion by Mr. Wheeler, a second by Mr. Nash. All in favor respond by saying aye.
Aye.
Motion carried. Second on the agenda is to approve the minutes from the April 2nd, 2025 board meeting. I'll accept a motion and a second if everyone has had a chance to review them and think they're in order.
Motion to approve.
Second.
Have a motion by Mr. Haynes, a second by Mr. Wheeler.
I don't think
Shows the fifth one down on mine.
Sorry.
I'd have a motion by Mr. Haynes, a second by Mr. Wheeler. All in favor, please respond by saying aye.
Aye.
Any opposed? Motion carried. Next on the agenda will be the legal report. Mr. Bryant, thank you, sir.
Good morning, board members. First complaint is complaint number 2025-006041. This case was administratively opened following a routine inspection conducted on December 18th, 2024. During the course of this routine inspection, the inspector observed the following. During the time of the inspection, an employee with an expired pre-need sales agent registration wrote one pre-need funeral sales contract with an expired registration. Respondent stated that when they were made aware of the part-time employee's expired registration, they immediately reached out to the employee to process the renewal, which was completed on December 19th, 2024. However, respondent provided that ultimately the employee's employment was terminated on December 23rd, 2024, and a companion complaint was opened on the pre-need side regarding that employee. Based on the above, we would recommend a $500 civil penalty, authorized via consent order, and a formal hearing if necessary.
Any discussion or questions on this case? If none, I'll accept a motion.
I make a motion we accept council's recommendation.
Have a motion by Mr. Wheeler. Does have a second?
Second.
Second by Mr. Haynes for a $500 civil penalty, authorized via consent order and formal hearing if necessary. All in favor, please respond by saying aye. Aye. Any opposed? Motion carried. Number two.
Next complaint is complaint number 2025-007801. This case was administratively opened following a routine inspection conducted on February 5th, 2025. During the course of this routine inspection, the inspector observed the following. Respondent establishment had an employee whose funeral director's license expired on October 31st, 2024. It did not meet the requirements for reinstatement until December 5th, 2024. During the unlicensed period, the employee continued to act in the capacity of a Tennessee funeral director in the following ways. It was listed as the funeral director on death certificates for 8 individuals, signed 1 statement of funeral goods and services, and signed 3 permits for cremation of human remains as the person in charge of cremation. Respondent apologized for the oversight involving their employee's expired license, stating that they accepted the responsibility for the establishment side of the oversight. Respondent stated the employee misunderstood the 90-day grace period to mean they were okay to operate within the 90-day period while renewing the license and communicated that to establishment leadership. Respondent stated regretfully they trusted this understanding and did not investigate further, stating it would never happen again. Based on the above, we'd recommend a $500 civil penalty, authorized via consent order and formal hearing if necessary.
I've just got one question. I made a note last night, Mr. Bryant. First case we just had with one pre-need was 500. This one is, there's 12 different counts of, I guess, doing contracts without being a licensed funeral director. Any maybe explanation on the same fine?
Yeah, essentially so. It's mostly to keep consistency with what the board's done typically of kind of your first-time offenses. I think the only disciplinary history this respondent had was back in 2018 for what looks like a itemization issue, which resulted in a letter of warning. There's definitely no argument that there was more activity in the second complaint than the first one. So the recommendation there is kind of a consistency starting point, but if the board feels that that heightened amount of activity warrants a higher civil penalty, then obviously that is certainly within the board's purview.
I guess my only comment would be, again, we go back to the problems of license expiring. The state does a great job in noticing those people that their license are due prior to them expiring. I think we all know our driver's license expire, our tags expire, and we have a date set. I understand they're using the 90-day grace period, but a 90-day grace period does not mean your license remain active. So I agree with Mr. Leah and feel that maybe the penalty, because of the offenses, and there were so many, and there was a length of time that went through that, I would recommend a $750 civil penalty.
Is that in the form of a motion, Mr. Wheeler?
Yes, sir.
We have a motion by Mr. Wheeler to change the civil penalty to $750. Is there a second?
I'll second.
Have a second by Mr. Nash. All in favor, please respond by saying aye.
Aye.
Any opposed? Motion carries for a $750 penalty. Authorize a consent order for a formal hearing if necessary. Number 3.
And real quick, sorry, Mr.
Sorry,
Lee.
that's okay.
No. Just a brief, just to add on to something Mr. Wheeler said for the benefit of everyone. We've mentioned this before, but if I have to remind everyone every month, that's fine. If we can avoid it, that 90-day grace period is that first day your license expired. You are not permitted to conduct license activity. It is expired. It's not any good. You can't use it. What that 90-day grace period is to allow, basically, if you go on day 91, that license is gone and you have to take a lot of steps to get that license back. That 90-day grace period is, hey, you let it lapse, you still can't practice license activity, but there are a lot shorter steps to get your license back into good graces, essentially. That 90-day grace period is not a thumbs up just to keep doing what you're doing. Excuse me. But it's administratively to make it easier to get your license back to where it needs to be, not an okay to just keep going. So just for the benefit of hopefully people listening, if that issue comes up again.
The grace period thing has come up several times over the last few months too, and I know we've talked about it a few times. Is there something we could do to remind people of that, maybe in the form of an email or something, just to remind them that?
Well, they're notified how many days out, Mr. Gribble, establishments and
Right, yeah, I
licensing?
understand that. I'm just saying that this just seems to be this grace period is a common misconception, even though they're notified. I know you guys have plenty to do. I'm not trying to create more work for you guys by any means. It just seems like it's been mentioned several times.
Well, there's a letter that goes out, Ms. Bohannon, you want to speak to that lets them know right after their license expires?
Yes, once a license expires, we send out it's like a late letter, a penalty letter, and explain in detail about what happens, what they need to do, the steps they need to take in order to get their license back active. It doesn't say anything about a grace period within that letter. You says you have 90 days, as explained by Mr. Bryant.
Yes, ma'am.
But it says nothing about a grace period. That's maybe it'd be a misinterpretation
That's
on
what
their part.
Right.
But we.
Does it
do
say anything in that letter about that at this point you are not licensed and they're not licensed?
It does.
until-
It says your
does that?
license expired as of
Okay.
this day.
So I'm just asking. I've never received one, so I'm just curious. Okay.
And
Thank you.
we can go back and review that letter and consult with Mr. Bryant and see if we can strengthen that where it's more informative.
Yes, sir.
And make them more aware, because it goes out just, prior.
Almost immediately.
Even though they get the notices to renew, once the license expires, this letter goes out very soon afterwards. So we'll look at the letter and see if we can be more informative, let them know the license is expired.
Yes, sir.
You cannot work as a funeral director and embalmer until you get those licenses reinstated.
Well, I think ultimately also it lies within our education of when someone's in mortuary school, that they have to take laws of your state. And that should be something maybe the schools ought to look at enforcing or bringing up, that when your license expire. But again, I go back, it's pretty much common sense. When your driver's license expires, before they expire, you go get new ones. Your tags are the same way. I mean, it's just pretty much, I think, common sense to use a 90-day grace period. That'd be like a surgeon lets his license expire and then he goes ahead and does surgery. You can't do that. It is just not permitted. And I think that's maybe just an excuse to use, hopefully, for a little reprieve by the board.
And I like to just say one more thing. When somebody sends in their payment and they don't have the required CE, we communicate with them multiple times. And through email, letting them know that if it's acceptable, if it's unacceptable. And the young lady that does that, she's very meticulous in sending that out and communicating with them. So we can look at the letter, and we've reissued the statement that we send out. So, but we do try to communicate as well as possible to let them know what is required of them to make sure they stay active.
I'm just gonna follow up and say that I appreciate what you guys do, and I didn't mean it in that way, in any way, but I appreciate the how diligent you and your staff are with that.
And one other thing, just so mainly for the benefit of those that might watch the meeting, if you pay late, you got to pay a penalty. We don't have any discretionary authority to waive that penalty. If it's a day late, then there's a $200 penalty on each license. If you pay on time, but you not completed your CE appropriately, then that's gonna, if you don't complete that by the end of the expiration license, then that means it's late. And then there's, in addition to doing your CE, then there's a requirement to pay a late fee, again, on those licenses, because you haven't met all the requirements to renew the license.
So what you're saying is, even if you've paid it and you don't have your CEs done, you're still gonna have to come back and pay the fee. Okay.
And then if you, and then if you do your CE late, you pay a penalty late, and you practice, then you're probably gonna pay a civil penalty for
I never
practice.
understood.
So it's expensive not to do it on time and
Much
not
like
to renew
Mr.
it on
Wheeler,
time.
and we see these, and well, three of us have been here for the last little over a year now, that we've seen so many of these cases where, I mean, this is your livelihood. This is how you make your living. This is how I make my living. How we all make our livings. And I just, it blows my mind that people I mean, I understand things happen, but when you, these long periods of time, I don't understand it. But anyways, I'll stop talking now.
Well, and I think ultimately for those that will be watching and all, that it lies with the licensee that your address and email is correct with the state. They can only do what we provide them as licensees of the state. So therefore, it is up to them to make sure if you move or you get a new email or whatever, that is relayed to the state of Tennessee so that they know how to contact you.
And I think you can pretty much do everything on core now, as far as looking at your license, your CEUs, your expiration, update personal information. So I think they've made it as simple as they can. So. No other discussion. We did
So, yeah,
do
that-
number 2, right?
correct.
Thank
So
you. I wanna
this will be
make
number
sure.
3.
All right, number 3, Mr. Bryant, thank
Yes.
you.
It's complaint number 2025007811. This case was administratively opened following a routine inspection conducted on February 5th. This respondent is the employee from the preceding complaint. And just as a reminder to the board, their funeral director's license expired on October 31st, 2024, was renewed December 5th, 2024, and during that unlicensed period, were listed as the funeral director on death certificates for 8 individuals, signed 1 statement of funeral goods and services, and signed 3 permits for cremation of human remains. Respondents stated they took responsibility for the violation, stating it was their understanding that they had 90 days to complete the continuing education for the funeral director and embalmer licenses following the date of expiration. Respondents stated they did not intentionally violate the law, but just misunderstood, and respondent apologized for the violation and provided that it would not happen again. And based on the above, we'd recommend a $500 civil penalty, authorized via consent order and formal hearing if necessary.
Any discussion?
I think since
Have a motion by Mr. Haynes, for a $750 civil penalty, authorized via consent order and formal hearing if necessary. Is there a second?
Second.
Second by Mr. Nash. All in favor, please respond by saying aye. Aye. Any opposed? Motion carries. Number 4.
Number 4 is complaint number 2025-010861. This case was administratively opened following a routine inspection conducted on February 24th, 2025. During the course of this routine inspection, the inspector observed the following. Respondent's manager allowed their funeral director's license to expire on November 30th, 2024, and did not meet the requirements to reinstate the license until January 16th, 2025. During the unlicensed period, in addition to not having a licensed manager of the establishment, the manager acted in the capacity of a licensed funeral director by being listed as the funeral director on the death certificate for 13 decedents and by signing 12 statement of funeral goods and services. The manager of respondent establishment replied, stating that they accept responsibility for the lapse of their license. Respondent explained that they hold multiple professional licenses and that they try and keep up with them on a spreadsheet, and that they had made a clerical error and mixed the expiration date of their funeral director's license up with their expiration date of a separate license. Respondent stated that it wasn't until they received an email notification from the state informing respondent of the upcoming lapse were they made aware. Respondent stated they then attempted to receive all of their in-person credit hours and that options were limited due to the holiday season. Respondent stated they finally found a suitable continuing education course, but that it was then canceled due to inclement weather. Finally, respondent was able to obtain the necessary hours the following weekend. Respondent apologized for the mistake and stated that they regret their, quote, lack of attention to detail and procrastination that led to the lapse. Would recommend a $500 civil penalty, authorized via consent order and formal hearing if necessary. I will say, in light of the board's decisions on the previous one, I would recommend that civil penalty be higher due to the nature of the activity on this one, just for consistency's sake. But
Thank you, Mr. Bryant. Any discussion?
I agree with counsel and with the respondent that they take full responsibility for attention to detail and the procrastination on their part. So I'd like to say that I think it ought to be for the number of offenses that it should be $1,000 civil penalty. And I make that in form of a motion.
Have a motion on the floor by Mr. Whaler for a recommendation of $1,000 civil penalty, authorized via consent order and formal hearing if necessary. Is there a second on the motion? I'll make a second on the motion. All in favor, please respond by saying aye. Aye.
Aye.
Any opposed? Motion carries. Number 5.
number 5 is complaint number 2025-010891. This case was administratively opened following a routine inspection conducted on February 24th. During the course of the routine inspection, inspector observed the following. The respondent here is the individual from the preceding complaint. Again, as a reminder, this individual was manager of the funeral establishment. Their license expired November 30th, 2024, was reinstated January 16th, 2025. And in addition, into being the manager of the establishment, they were listed as the funeral director on 13 death certificates and signed 12 statement of funeral goods and services. And the original recommendation being $500 civil penalty, authorized via consent order and formal hearing if necessary. But again, given the board's previous determinations, that likely should be higher for consistency's sake.
Any discussion on the motion? The recommendation?
Make a motion to increase the penalty to $750.
Have a motion on the floor by Mr. Nash to increase the civil penalty to $750. Do I have a second?
Second.
Have a second by Mr. Whaler. All in favor, please respond by saying aye. Aye. Any opposed? Motion carries. Number 6.
Number 6 is complaint number 2025-010931. This case was administratively opened following a routine inspection conducted on February 26, 2025. During the course of the routine inspection, the inspector observed the following. An employee of respondent establishment had allowed their funeral director's license to expire on January 31st, 2025. The employee did not meet the requirements to reinstate their license until February 5th, 2025. During the unlicensed period, the employee served in the capacity of a funeral director for 2 decedents by signing the cremation authorization form. The employee of respondent establishment replied stating that the 4-day lapse was due to lacking one in-person continuing education unit and that they had undergone abdominal surgery on January 8, 2025 for a serious health issue. Respondent stated that after their recovery, they sought out in-person options for continuing education, but were unable to find the last hour before the license lapsed. The employee stated that on February 4th, 2025, they completed 2 in-person continuing education hours, and the license was reinstated on February 5th, 2025. The employee, who had previously been the manager of the establishment, met with the owner and established a compliance plan, went through the formal process of changing themselves from the manager of the establishment, so respondent establishment would not have an unlicensed individual as manager. The employee stated that for both of the cremation authorization forms, the authorizing agent signed the authorization form on February 1st, 2025, and February 3rd, 2025, respectively, but that unfortunately on the authorization form, there was not a place to date the funeral director's signature. The employee stated that they signed both forms on February 6, 2025, and February 12th, 2025, respectively, both dates after the license had been reinstated. As proof that these were not signed by the employee at the time of an expired license, respondent provided the form with faxing information to show the day that each form was faxed to the crematory. Both faxes are consistent with the respondent's timeline, as they were faxed on February 6, 2025 and February 12, 2025, respectively. Based on the above, the employee took steps to remove themselves from the managerial role prior to their license expiration, knowing they were an hour short, avoiding violation for having an unlicensed individual operating as manager. Likewise, respondent provided evidence to suggest that the 2 instances of license activity signing the cremation authorization form occurred after February 5th, 2025, when the license had been reinstated. As such, there is no evidence that the respondent establishment had an unlicensed manager, nor permitted an unlicensed employee to conduct license activity. However, respondent did not date the cremation form as required by statute. Thus, for that and not for the reasons found in the inspection, legal would recommend a letter of warning.
Thank you, Mr. Bryant, for especially being that detailed on this. I'll open it up for any questions, comments.
I make a motion to accept.
I do have a question, excuse me. I apologize. So the state requires that the form have a date on it when it is signed, but their form does not. Is that correct?
That's correct. My recollection from this case file is that it was the crematory's form that there's a signature line there, and then at the end of that line, there is not a spot for a date. You could squeeze one in there, but it does not have a notated spot for a date.
So I guess my question would be, is the crematory operating by statute?
On that form, I guess it gets tricky in the sense that the statute requires that it be dated. Would it be prudent, and I would, not even legal advice, smart to have a spot to date so the funeral director knows to date it? Yes, without question. I guess the form itself not having a notated spot that says date is not in itself a violation, but it really sets funeral directors up for this exact scenario where, I don't have a spot to date it, I'm just not going to be able to put a date in, and then that goes afoul of the statute.
Well, I guess my question would lie, if you don't date a form as required by statute, someone technically could come in today, sign a cremation form, and the death occur 2 years from now, and that form be slid through for the cremation. It's technically not a legal form. So I guess my question would be, should the crematory also receive something from the state stating that they are in violation of a statute?
I think so. To my knowledge, a complaint is not open on the crematory. One thing I'm happy to do as a potential, resolution here is, in addition to the letter of warning, I'm happy to author a letter to the crematory and say, look, you're setting funeral directors up to make a mistake in violation of statute. It's arguable and possible that you not having a date notated there is a violation. We don't have to get into that. You can just fix it. I'm happy to do that and reach out to them.
Okay, and I would like to say, and I'll second Mr. Nash's motion, but with the letter of warning, I think the funeral home needs to be noticed. They should not be signing any cremation authorization without dating it, that it goes against statute.
For my benefit, Mr. Bryant, is this the family authorization, the permit, or the paperwork crematory has when they receive a body?
My recollection on this one is that it was the family authorization form that it had the. And if I remember, I'm going off. I don't want to tell you all the wrong thing, but I think that the family had dated it. There just wasn't a line because again, with I'll give credit to the respondent. They were very helpful in laying this timeline out. And the timeline doesn't make sense if the family didn't date it. So I think it is the family authorization form from my memory.
So are you saying the family did date it?
I think from my recollection, I don't want to tell you the wrong thing, but
So here I go. I question what date did they put down? Because those of us who wait on families, usually when they sign it in front of us, we sign it immediately after their signature and date it. And I'm questioning now the dates, if they're coincide with what the funeral director is saying, or if the family has a date a week prior. And we all know I don't think the funeral home would wait a week before they signed off on a cremation.
and I remember looking at that. I know Mr. Grimmel and I spent a lot of time going through it and my edification of that process. And I know everything with respondent laid out, the timeline seemed to match what they provided. They had faxed over those documentation, the documentation to the crematory, provided dated timestamps, faxes over, and it matched everything. So that's one thing we certainly spent a lot of time talking about. And I do think, based on the evidence we have in front of us, the timeline provided by a respondent is accurate. So it's we were happy to see that the evidence suggested there was not a larger problem here. But
So I'll second Mr. Nash's motion, and that both the funeral home and the crematory be noticed. Everything needs to be dated per statute.
Got a motion on the floor by Mr. Nash, second by Mr. Wheeler, to accept council's recommendation of a letter of warning. All in favor, please respond by saying aye.
Aye.
Any opposed? Motion carries. Number 7.
and the next complaint is complaint number 2025-010951. This is the employee slash former manager from the preceding complaint. So again, for all of those reasons, the recommendation would be the same, that letter of warning, and likewise, essentially the identical motion of what was put in for the previous one.
Any discussion?
I'll make a motion to approve.
Second.
Motion by Mr. Nash, second by Mr. Wheeler, to accept council's recommendation of a letter of warning. All in favor, respond by saying aye.
Aye.
Any opposed? Motion carries. Number 8.
Number 8 is complaint number 2025-01487. This case was administratively opened following a routine inspection conducted on March 13th, 2025. During the course of this routine inspection, the inspector observed the following. Respondent establishment had an employee who permitted their funeral director's license to expire on December 31st, 2024, and did not meet the requirements to reinstate the license until January 28th, 2025. During the unlicensed period, the employee acted in the capacity of a licensed funeral director by signing 6 permits for cremation of human remains as the person in charge of the cremation. Respondent stated that the employee failed to meet the continuing education requirements for in-person hours. Respondent stated they looked online to verify if the employee's license was active, saw the words grace, and interpreted that to mean the employee had a grace period to complete the requirements. Respondent stated that during the unlicensed period, the employee did not perform any of their normal license responsibilities, or that he was directly under the supervision of a licensed funeral director, including during the cremation process, where the manager stated they personally directly supervised the entire process. However, respondent stated the employee did sign the certification of the person in charge of the cremation, and that it, quote, should have been my signature, and I do apologize, the employee signed these out of habit, end quote. Based on the above, we'd recommend a $500 civil penalty, authorized via consent order and formal hearing if necessary.
Any discussion? If not, I'll accept a motion on council's recommendation.
So move.
Have a motion by Mr. Whaler. Is there a second?
Second.
Second by Mr. Haynes. All in favor, respond by saying aye. Aye.
Aye.
Any opposed? Motion carries. $500 civil penalty. Authorized via consent order and formal hearing if necessary. Number 9.
Next complaint is complaint number 2025-019501. This case was administratively open following a routine inspection conducted on March 31st, 2025. During the course of this routine inspection, the inspector observed the following. Respondent's funeral director's license expired on January 31st, 2025, and did not meet the requirements to be reinstated until February 7th, 2025. During the unlicensed period, respondent signed one authorization for cremation disposition of human remains. Respondent stated they experienced health issues that resulted in their admission to the hospital for a week and a half, and that they had all of their hours except 2 in person, which had been scheduled prior to their admission to the hospital and thus were missed. Respondent stated they were able to get their hours soon after, but in the interim informed establishment staff that they would need to wait on families and in the interim informed establishment staff that they would need to wait on families and sign contracts and documentation due to their expired license. Respondent stated during their unlicensed period, a family walked into the establishment with an at-need death and were adamant that they wanted to make arrangements at that time. Respondent stated the family was, quote, very stern, agitated, and sometimes rude, end quote, and that respondent ultimately obliged the family to ease the confrontation. Respondent stated that when this occurred, they had already received their hours and had submitted it to the state, but had yet to receive the certificate stating the license was renewed. Respondent stated they were not offering this information as an excuse, but just to explain the facts and context surrounding this one instance of unlicensed activity. And based on the above, we'd recommend a $250 civil penalty, authorized via consent order, and formal hearing if necessary.
Any discussion? Questions? If not, I'll entertain a motion.
So moved.
Have a motion by Mr. Nash to accept council's recommendation, $250 civil penalty, authorized via consent order and formal hearing if necessary. Is there a second on the motion?
Second.
Second by Mr. Haynes. All in favor, please respond by saying aye. Aye. Any opposed? Motion carries. Number 10.
Okay, we are out of the expired licensed complaints. Next complaint is is complaint number 2024-068371. Complainant stated that their grandmother had passed away on April 22nd, 2014, and had prearranged and prepaid for a funeral at the funeral establishment the respondent had previously owned. Complainant alleged that the trust was never lawfully validated by the trustee due to forgeries made by other family members, specifically stating that her mother had the same name as the grandmother and that her mother had signed documentation as the decedent. Complainant also alleged that her sister had signed documents at the funeral home impersonating complainant. Respondent replied stating that this occurred over 10 years ago and that they had no knowledge or recollection of this situation. Respondent explained they had sold their interest in the funeral establishments 18 months ago and no longer had access to any documentation that could even be related to the complaint. Likewise, respondent pointed out that they were never named by name in the complaint and that the allegations appear to revolve around forgeries on behalf of complainant's family members, and that the funeral establishment was not implicated or alleged to have violated any statute or rule in the complaint. Based on the above, complainant's allegations do appear to revolve around alleged wrongdoing on behalf of their family members. Complainant does not articulate exactly what they are alleging the respondent to have done to contribute to any violations of applicable rules or statutes, so we'd recommend closure with a custom closure letter to complainant advising them to pursue civil relief if they are concerned about alleged wrongdoing of their family members.
Any discussion or questions? If not, I'll entertain a motion.
So moved.
Second.
Have a motion by Mr. Nash, second by Mr. Wheeler for closure. All in favor, please respond by saying aye.
Aye.
Any opposed? Motion carries. Number 11.
Next complaint is complaint number 2025-013351. Complainant, daughter of the decedent, stated that respondent had sold a prepaid cremation policy to the decedent with charges as $1,505.95. Following the decedent's passing, the decedent had an $87 cash advance item for the obituary, which respondent went to process. However, complainant alleged that respondent accidentally double-charged complainant for the entire original $1,505.95 plus the cash advance item. Complainant stated that respondent indicated they would have to process the refund through corporate on the credit card used, and complainant alleges they have been getting the runaround since. Complainant stated that at one point, respondent had received authorization to issue the refund from corporate, but then revoked it the next day because complainant had filed a dispute with the credit card company. Respondent replied stating that she met with the family on February 28, 2025, and went to process the remaining $87 for the obituary, but that when going to do so, inadvertently charged the total at-need cost without deducting the prearrangement to the credit card. Respondent stated they immediately realized their mistake and apologized, saying it would be refunded as soon as possible and that they would follow up with an update on March 12, 2025. Respondent stated they were not entirely clear on how to reverse the credit card charges, but would normally ask the office manager for assistance, but she was on leave. Respondent, however, did contact an office manager of an affiliate location who contacted the corporate office on respondent's behalf. Respondent stated they were told the insurance would need to issue payment before a refund could be processed, so respondent immediately sent the insurance documentation on February 28, 2025. Respondent stated they were on leave the following week, beginning March 5th, 2025, but asked a colleague to follow up with the insurance company so an update could be provided on March 12th as promised. When respondent returned, they contacted complainant and realized the refund had not yet been issued. Respondent apologized, said she would look into it and report back the same day. Respondent stated they realized the insurance had not paid out yet and was able to have the corporate office issue the refund after receiving written documentation from the insurance company guaranteeing payment as requested by the refund department. Respondent stated they forwarded this information to complainant to let her know the refund check would be ready the next day, but then complainant informed respondent they had filed a dispute with the credit card company. Respondent explained this dispute caused another delay as they could not issue a refund with a credit card dispute pending. Respondent stated they informed complainant of this and even offered to provide the refund from their own personal bank account. However, respondent stated they were ultimately able to issue the refund check and delivered it to complainant on March 17, 2025. Complainant's complaint was filed March 14, 2025. Respondent apologized for all the complication resulting from their mistake and apologized to the complainant and their family. Respondent also attached a copy of the receipt associated with the refund, and I spoke to complainant as well and confirmed that that refund was received. So based on the above, the respondent appears to have made a mistake and took reasonable efforts in attempting to rectify that mistake, and based on that, we'd recommend closure.
Thank you, Mr. Bryant, and I agree with that. I think the funeral director did everything he or she could to rectify this. I'm not too happy with corporate, but sadly, that's wasn't who the complaint was filed against. Any other discussion or motion?
I make a motion we accept council's recommendation.
Have a motion by Mr. Wheeler. Is there a second?
Second.
Second by Mr. Haynes for closure. All in favor, respond by saying aye. Aye. Any opposed? Motion carries. Number 12.
Next complaint is complaint number 2025-005061. This case was administratively opened following a routine inspection conducted on January 21st, 2025. During the course of this routine inspection, the inspector observed the following. Following the death of respondent's manager on November 1st, 2024, at the time of the inspection, there was no manager listed for respondent establishment. Respondent did have a licensed funeral director and embalmer during this period. However, this individual was not listed as the manager of the establishment. The inspector returned on February 4th, 2025, and determined that during this time, respondent conducted 26 funeral cremation services without a proper manager. Respondent replied confirming that their manager did unexpectedly pass away on November 1st, 2024, and that upon his passing, they began an immediate search for a new manager of the establishment. Respondent stated that unfortunately the search took much longer than expected, but that they had hired a new manager on February 5th, 2025. Respondent further stated that for the entire period, respondent establishment did have a licensed funeral director present with all families and worked services, and that at no time did they conduct unlicensed activity without a funeral director present. Based on the above, although there does not appear to be any evidence of unlicensed activity, respondent operated from November 1st, 2024 until February 5th, 2025 without a proper manager, conducting 26 services without a proper licensed manager. Based on that, we'd recommend a $2,000 civil penalty, authorized via consent order and formal hearing if necessary.
Thank you, Mr. Bryant. Real quick, if you have a sudden death of a manager, what is the time frame do they notify the board, or did they notify and say, hey, this happened overnight, or what do we need to do? And I'm also curious if they had a licensed funeral director and embalmer there, maybe why that person didn't help relieve. I'm trying to find a,
Sure. On the latter question, my understanding is that this individual was a friend of the manager that passed away and came in to help as a licensee. My understanding is that they also are employed at another establishment and couldn't be manager, but could be on hand to take care of all the license activity, which, in the scheme of things, I'm relieved they had that because it could have been a lot worse. As far as so it's tricky in that under the rules, the change for manager is you're supposed to notify the board within 10 days. That is obviously normally contemplated to be someone moving on or leaving, not unexpectedly passing away. We understand the difficulty of that kind of coming out of nowhere and finding someone to replace quickly, but it's the trickiness of I think to be completely safe under the law, if that happens, if you're not able to find a replacement within 10 days for that notification, in the interim while you don't have a manager, you should not be conducting business. And again, understand that that's such a tricky circumstance, but that under the law, you're not allowed to conduct without a licensee as manager. And if you have a new one, you've got 10 days to notify the board of that.
So I guess my question is, did the establishment notify the state that the manager had died and they were without a manager in place? Or was it through just inspection by the state inspector? The other question, is it just knowledge of anyone, be it private-owned or corporate, that each establishment is to have a licensed manager for that establishment? So I guess, Mr. Gribble, that falls to you.
Okay, question one is, the funeral home did not notify the board that they were without an establishment. But due to knowing the death of the licensee, we were aware that they were. What happens when you have unlicensed owners and you're operating with only one funeral director on staff who is the licensed manager? That's a situation that these folks fell within.
That was my question. Is the respondent, the owner, is not licensed? So
Not non-licensed, and the only funeral director that was employed by the establishment was the manager who passed away.
but they do now have a manager.
They do.
He did continue to conduct business on a normal daily basis without a licensed manager of the establishment.
Correct. Based on what was found from November 1st up until February 5th, that's the period without a manager. Based on what the inspector found, there were 26 instances of services or cremation.
It's almost 3 months, quarter of a year, he conducted business, knowing what the state law requires.
Did the inspector confirm that of these 26 services that a licensed funeral director signed the statement of good services was listed on the death certificate as the same person, I guess? Or anything, do we know if any of that was confirmed?
Yes. So again, when the inspector was there initially and then came back on the 4th of February, my understanding is that essentially pulled everything, that those 26 saw that, no evidence of unlicensed activity, that funeral director who was not manager but was kind of covering in that interim had been there to prevent it from just being non-managed, unlicensed activity. So stop the bleeding in that regard. But
The other thing I'd like to bring attention to is just in 2023 and 2024, if we'll look, it's not the first time this establishment was conducting this activity.
this location has had difficulty with managers. I definitely don't want to paint this one in the light as the former because, passed away, which no one could have expected. But they have had difficulty finding managers in a timely fashion and kind of just operating as usual in that interim. So
I make the motion, we accept council's recommendation with a $2,000 penalty.
Have a motion by Mr. Whaler to accept council's recommendation to $2,000 civil penalty, authorized via consent order and formal hearing if necessary. Do we have a second?
Second.
Second by Mr. Nash. All in favor, please respond by saying aye. Aye. Any opposed? Motion carries. Number 13.
next complaint is complaint number 2025-008651. Complainant, the beneficiary of the decedent's estate, stated that the decedent was laid to rest on October 28, 2023, and that as of the date of their complaint, February 19, 2025, they had yet to receive a valid death certificate. Complainant stated they had repeatedly contacted respondent with no response back. Respondent replied stating that there had been information provided to them that was incorrect. Respondent stated that they corrected the first two mistakes identified, and then a third was found in late 2024. Respondent stated that they have submitted that correction and have gone in person to the Vital Records Department to pay for the correction being made and should have the corrected death certificate in a few weeks. Respondent replied on March 7th, 2025. Respondent stated they will not be charging the family the cost of correcting the death certificates and that they would call the family the day they received the corrected certificate. Legal contacted complainant on May 5th, 2025 to determine whether respondent had provided the corrected death certificate. However, as of this date, legal has not received a response. Based on the above, would recommend a letter of warning.
Any discussion?
Yeah,
Questions?
I have a few questions on this one. For those of us, and all of us sitting here file death certificates, we know you go ahead and file the death certificate with the state once you receive that information. Once that's filed with the state, you get the death certificate back. If the family comes back to you and says you've got this wrong or that's not the correct information, we file amendment with the state Vital Records Department. But that death certificate continues. I have a lot of problems with the death occurring in October and still a death certificate not being issued. We're a year and a half. I mean, you've tied a family's hands to where they can't do anything without a death certificate. So this just a lack of doing the business as a establishment but should be doing, because you go ahead. I have a lot of families. We will have someone who might be homeless and there's no family, but we still file death certificate, and a lot of times it's unknown. You put unknown. Then if someone steps up and says I'm a cousin or whatever, and this needs to be corrected, we file the amendment with the state. So I don't know. I just find that the funeral home the establishment has lacked doing their job as they should have at the time the death occurred.
And I think to just for clarity, I do think that they have filed that amendment since they're not clear if they say the two mistakes were. They filed it, found two mistakes, and then filed the amendment, or those were two separate filings that they caught later that required, we fixed one, okay, we saw another one, we're going to do another one, then a third. So I do think it has been filed. Based on my understanding, one thing I will say that was tricky on this one is it kind of cuts both ways, too, of a complainant has the burden in their complaint to show. And with this one of reaching out and trying to get more information of, was there actually a mistake? What was it? Did they get that corrected? Do you have your certificate? Without getting information, it puts, I think, the board in a tricky spot of, we've got these questions that aren't, we just don't have a way to answer right now because complainant didn't get back to me on that. But, excuse me, all of that to say, I do think they've been filed. Whether it kind of the incorrect one that needed to go back and have an amendment be made was given to the complainant, and the complainant said this isn't right, I can't use this, I'm not sure. That's one question I had for a complainant. So that's the reason for the recommendation of letter of warning. I had those same concerns, especially when we're talking about a death that occurred in 2023. But just given the uncertainty of exactly how involved was respondent. That's the reason for the letter of warning recommendation.
the way that I had read this was that a death certificate had been filed. They just didn't receive a valid one. I'm assuming they're saying the corrected one. Now, I did notice, and guys, correct me if I'm wrong, they said they weren't going to charge the family what they had to pay the state. You don't have to pay for an amendment till after 6 months.
Yes, sir.
So I'm assuming it had been filed and they found the mistake at least 6 months later. So I understand exactly what you're saying. That's the way I read that.
I have a question for council. The death certificate that has already been amended one time, and this is gonna be a second go-around. Don't you have to go to court to do that?
You have to have a court order for this, if you're amending the same death certificate twice.
Yes.
So
First
that
time you
might have
filed
been
it,
part of the
filed it.
delay getting the court date.
Yeah, that's certainly a possibility.
But to end it, you still have not gotten a response from the complainant.
Correct. I have not.
Thank you, sir.
And the establishment hasn't said they've gotten a death certificate to the family either, correct?
So in their response, they said, let's see. So they replied on March 7th of this year, said at that time they should have a corrected death certificate in a few weeks. So, I mean, assuming their timeline was accurate, then they have gotten it to the family. Attempting to confirm that with complainant was unsuccessful, but based on what they communicated in their response at that time, then that would have been provided at this point.
Any more questions or comments, gentlemen? If not, I'll entertain a motion. Based on my interpretation and based on council's explanation and recommendation, I'll offer a motion for council's recommendation of a letter of warning. And
I'll second that.
we have a second by Mr. Nash. And I'm sure if things hadn't followed up, they'll file a complaint that they don't have it, and we can revisit that issue. All in favor, respond by saying aye. Aye. Any opposed? Motion carries for a letter of warning. Number 14.
14, complaint number 2025-006831. Complainant, aunt of the decedent, stated that their nephew died on December 14th, 2024. Complainant stated that the arrangement was for a December 19th, 2024 family viewing and burial following the visitation. Complainant stated they were assured by respondent staff that the decedent's face looked good and that no trauma would be seen on the side of the decedent's face. Complainant alleged this was false, stating that the right side of the decedent's face, quote, had been shaped like wax and his makeup was flaking off, end quote. Complainant further stated that as the family was viewing the decedent, there was blood running out of the decedent's left ear. Complainant stated that around 1 p.m. body fluids began to seep out of the decedent and was witnessed by complainant and the mother and sister of the decedent. Complainant claimed that when it was time to close the casket, the decedent's shirts were, quote, soaking wet, not just damp, end quote. Complainant stated they did not take pictures of the decedent. Complainant attached the contract and stated that they gave approval for and paid for embalming and were concerned that it had not actually been performed. Complainant stated that at the graveside service, staff lowered the decedent into the plot and that the family was still gathered at the graveside mourning. Complainant alleged that staff appeared impatient to leave 15 to 20 minutes after the service had concluded. Complainant provided further information stating that as the mourners were leaving, about 30 or so vehicles did a, quote, burnout at the entrance of the parking lot. Complainant admits this should not have been done, but stated that respondent staff had called the police and that eventually 10 to 12 police cars were in the parking lot. Respondent stated that they have contracted with the local sheriff department to transport a decedent and clear the scene of any accident in their county. Respondent stated they work closely with the medical examiner's office in the area to coordinate delivery and receipt of local deaths in their county. Respondent explains that they bring the decedent into their care, hold them until a medical examiner comes to pick them up, or they deliver downtown. Respondent stated that they picked up the decedent in this matter and that their understanding was that it was a single-car accident traveling at a speed of more than 120 miles per hour. Respondent stated they explained to the family that they were only the holding facility while waiting for the medical examiner's pickup, but that the family did choose to use their services as a funeral establishment. Respondent stated that first, their director on call spoke to 2 to 3 different women who all purported to be the mother of the decedent. Respondent stated that finally, the aunt of the decedent complainant admitted she was not the mother of the decedent, was the aunt, and that she would be the point of contact moving forward. Respondent stated the family was adamant about seeing the decedent and collect his personal belongings, but respondent explained that they could not release anything to the family until the medical examiner had performed the autopsy. Respondent stated that the family was adamant about not having an autopsy done, but that they explained it was ultimately up to the medical examiner's determination. At this time, complainant informed respondent that they wanted to use their funeral establishment, and respondent explained that once the decedent was released to them, they would set up a time for the family to make arrangements for visitation and service. Respondent included a copy of the embalming report, stating the decedent was embalmed at the permission of the father. Respondent provided there was a lot of trauma to the body, but they felt certain an open casket would be possible. Respondent stated they explained to the family that they would do their best to cosmetize the laceration on the lip and face, but due to the fact the decedent was in a bad wreck, there was a significant amount of trauma to the body that wasn't noticeable to the eye. Respondent stated that this also explained and this is also explained and doubly so here when an autopsy occurred and that the decedent is fragile. Respondent, they take every precaution to prevent leakage, but that with such a fragile decedent due to the wreck, trauma, and autopsy, they let the family know they needed to remain, quote, very hands-off. Respondent stated that upon the family's arrival, the mother was very clearly in mourning, yelling and screaming, requesting to see the decedent. Respondent stated they reminded the family they needed to remain hands-off, but that the mother was, quote, inconsolable and not concerned with our warnings at all, end quote. Upon permitted into the chapel, respondent stated the mother began touching the decedent's face, chest, arms, and hands. Respondent claimed that they even witnessed the mother looking up the decedent's nose. Again, the staff generally reminded the family and the mother to not touch the decedent. Respondent stated the mother continued to lean over the casket and lay on the decedent's body while screaming and crying. Respondent stated that staff provided a bar stool height chair so the mother could sit next to the casket but not lay on it. Respondent also stated that the mother had touched the decedent so much that the casket had to be readjusted because it had been pushed off and lain on. Respondent provided that even after this, the mother continued to lay on the decedent to the point that many were unable to view the decedent. Respondent acknowledges that the mother was clearly in mourning and that it was heart-wrenching to witness, but that the warnings to not lay or not touch the decedent went unheard. Respondent stated around 1 p.m., the decedent's father spoke to the funeral director, informing him that they could see blood puddling in one ear on the decedent's non-viewing side. The funeral director went to the casket, cleaned up the area, and reminded the family to remain hands-off. Respondent stated there was no other leakage present except the tears on the decedent's shirt from where the mother had been laying. Respondent stated the funeral director even checked the neck and wrists of the unisols to ensure that there was no other leakage present. Respondent also stated that the family chose to leave the casket open for public viewing, and if there were the issues that they had reported or his appearance wasn't acceptable, the family could have requested to close the casket for the public viewing portion of the visitation, but that they did not. Respondent stated that no one was rushed from the gravesite and added that their staff did not leave following its conclusion, but began to load flowers, plants, and other memorabilia the family had brought for the service into the father's truck bed. However, following the service at around 4:08 p.m., many people in attendance began to do burnouts in the parking lot, and the police arrived soon after. Respondent provided that one of the trucks even attempted to run from the police and was ultimately arrested by an officer. Respondent stated an employee observed several trucks lining up at the entrance of the cemetery doing burnouts with smoke flying into the air. Respondent stated they later learned that several calls were made to the local police department, thinking the smoke and noise had been a wreck or vehicle on fire. The employee stated that the father apologized for the burnouts but said it was in honor of the decedent and left his name and number on the desk of the office, offering to pay for any damage done. When the police went to speak to respondent, the owner stated they wished to move forward with pressing charges due to the damage done. Respondent stated once the family realized they were moving forward with pressing charges, the entire attitude of the family changed, and that complainant began to become confrontational, yelling at police officers and threatening to sue respondents. The owner stated that the employee eventually called her and that complainant cussed her out over the phone and threatened to fall in the parking lot in order to get hurt and sue respondent. Respondent stated she explained that her insurance company would require a police report and would look to collect from the individuals responsible, and that was unfortunately the only way they could ensure that the damage and repair would be paid for. Respondent stated the father spoke later that week and expressed his satisfaction with the services provided and was willing to contact the family of the kids who did burnouts to help gather money to repair the parking lot. Respondent and the father spoke for an hour and expressed how they don't wish for the kids to be charged, but agreed that the damages must be paid for. Respondent stated it is their belief that complainant had filed the complaint to retaliate against the establishment because she was upset about their pressing charges for the damages, and contended that if the issues complainant had accused them of were true, they would have requested they close the casket. Respondent again stated there was no leakage present, only tears. Respondent attached the police report and the narrative of several officers that supported Respondent's sequence of events. The narrative stated that the funeral establishment had received a quote of $17,650 to repair the assault damage. Legal spoke to Respondent on April 22nd, 2025, who indicated that as of that date, they'd only received $3,000 for the damage done to their parking lot, and based on the nature of the charges, would likely not receive more, leaving them at a loss of $14,650. Based on the above, we'd recommend closure.
Thank you. Any discussion or questions, gentlemen? If not, I'll entertain a motion.
Motion to approve.
Second.
Motion by Mr. Nash, second by Mr. Wheeler. All in favor, respond by saying aye. Aye. Any opposed? Motion carries. 15.
Next complaint is complaint number 2025-009281. Complainant stated that on December 27, 2024, they had contracted with Respondent Establishment to receive 2 urns via USPS to intern 2 family members into a personal columbarium. Complainant stated that Respondent confirmed receipt of the remains on December 28, 2024, but as of the date of the complaint, February 23, 2025, they had not entered the urns. Complainant stated that they had requested photographs in the interment showing each urn in place so they know the interment is complete, but they have received no confirmation or pictures to show the service has been completed. Respondent stated they received and signed for the urns in early January, but that they were not able to install them at that time. Respondent stated complainant was working with a monument company out of state that was installing the niche columbarium for complainant at the out-of-state cemetery. Respondent stated that during the month of January, there were prolonged periods of inclement weather, delaying the monument company from installing the monument until January 25th, 2025. Respondent stated that due to more inclement weather at the end of January and at-need services at Respondent Establishment, they were unable to install the weekend of January 31st through February 2nd. Respondent stated they texted complainant on February 7th, letting complainant know they were not feeling well but hoped to install the urns that weekend. However, Respondent stated they were diagnosed with COVID after continued symptoms on February 11th and was told to quarantine for the rest of the week. Respondent stated the urns were ultimately installed at the out-of-state cemetery on February 23, 2025. Complainant provided a rebuttal stating that they had received a text message from Respondent Establishment on February 28, 2025, stating that the interments took place on February 23, 2025, and that pictures were sent to show the urns in place. Complainant stated this was the first they had heard of the interment occurring or seeing any photographs, and had requested that they be provided sooner because the burial instructions were not followed. Complainant explained that the small urn had been placed in the wrong niche. Complainant stated they informed Respondent on February 28th that it had been done incorrectly and asked for it to be corrected, and received confirmation it would be fixed on February 29th. However, Respondent stated as of the date of the rebuttal, March 6, 2025, they had not heard from Respondent or received any photographs showing the issue had been corrected. So, legal contacted both complainant and Respondent to receive an update. Respondent stated that after the text message sent to complainant on February 28, 2025, stating that an urn had been installed, Respondent asked complainant to call him to discuss. The next day, based on the text provided, complainant informed Respondent it had not been installed correctly and asked that it be corrected. Respondent replied in the affirmative. On March 6, 2025, based on the text provided, complainant contacted Respondent again asking for an update and to send photographs to show that the urns had been installed correctly per their wishes. In legal's conversation with Respondent stated that the urns had been correctly installed following complainant's text messages, but that he had not contacted complainant because complainant never called him like he requested. Respondent stated to legal that he had not had any additional form of communication with complainant and had not sent photographs to show that the urns had been installed the way complainant had requested. So based on the timeline provided, December 28, 2024, Respondent receives the urns to install in an out-of-state cemetery. January 25, 2025, monument company finishes installing the niche so that the urns may be placed. January 31st, February 2nd, inclement weather and at-need services at Respondent Establishment prevented Respondent from installing the urns. February 7th, Respondent texts complainant saying they feel unwell. February 11th, Respondent was diagnosed with COVID, told to quarantine for the rest of the week. February 11th was a Tuesday. February 23rd, the urns are installed at the out-of-state cemetery. On February 28th, respondent texts complainants a photograph of the urns and informs they were installed 5 days earlier. Respondent asks complainant to call them. That same day, complainant informs respondent via text that the installation was incorrect and asks respondent to correct it. On February 29th, respondent replies in the affirmative to correcting the installation, but did not send photographs at that time. At some point after, respondent purportedly corrected the installation but informed legal that they had not further communicated with complainant regarding the correct installation because complainant had not called them as their text message requested on February 28th. Legal also spoke with complainant who confirmed they had not received any additional communication from respondent despite asking for photographs to show that the installation had been corrected. In further communications with both complainant and respondent ultimately provided photographs showing that the installations had been corrected to complainant's satisfaction. So based on all of that, it is a happy ending. We recommend a letter of warning. I spoke to respondent and essentially just said, hey, send her the pictures. And he sent the pictures. I coordinated with complainant. She said it's all she wanted. She's happy. She appreciated that. So letter of warning recommended for just not taking those final communication steps, but that's legal's recommendation.
Thank you very much, and we appreciate the small things that heads off a lot of others. Any discussion? If not, I'll accept a
Motion to accept.
motion. Sorry. Motion by Mr. Nash, second by Mr. Wheeler to accept council recommendation letter of warning. All in favor respond by saying aye.
Aye.
Any opposed? Motion carries. 16.
Next complaint, complaint number 2025-011761. This case was administratively opened following a routine inspection conducted on March 5th, 2025. During the course of this routine inspection, the inspector observed the following. 1, respondent's website listed the physical address as city, not town within city municipal limits. Respondent replied stating that the town is within the city limits of the city identified and that the city is literally located or that the business is literally located in the city stated. Respondent further stated that it did not list the address on their website, but made statements such as proudly serving city, which respondent states is true. However, in an effort to avoid confusion, respondent has changed their website to say located in town. 2, respondent had the same distinction on their statement of funeral goods and services selected. Respondent stated again that this has been adjusted on their statement of funeral goods and services. And 3, respondent also listed an affiliated location on their website that had been closed since January 7th, 2025. Respondent stated that this was an error based on a failure to update the website and that reference to the closed location has been removed from respondent's website. Based on legal's review, the first 2 findings do not appear to be violations, and respondent has taken steps to minimize any potential confusion. The primary issues appear to be the affiliated location listed on respondent's website for nearly 2 months after its closing. Based on this, legal recommends a letter of warning associated with the 3rd finding only.
Any comments or discussion? If not, I'll accept a motion.
So moved.
Motion by Mr. Nash to accept letter of warning. Do I have a second?
Second.
Second by Mr. Haynes. All in favor respond by saying aye.
Aye.
Any opposed? Motion carries. Number 17, 18, are they together, Mr. Bryant, or are they just
Yes, that is correct. And this one's a little unique. First, complaint number 17 is complaint number 2025-008461, representing the respondent's funeral director's license. And complaint 18 is 2025-010291, representing the respondent's Embalmers license. So this matter with the subsequent cases represent a matter originally presented to the board at the February 25th, 2025 meeting. So as a reminder, take it a little out of order. I will read the represent first, just so everyone's refreshed and we're up to date. Then I'll give you the update. Complainant on this one filed new complaints with the additional information. So just as a refresher, so this is a represent from, okay, just to keep everyone on the same page. 17 and 18 are the new ones with the same respondent that is in 19 and 20, which was previously considered at the February 2025 meeting. So I will read the original presentation on 19 and 20 and then go back and provide the board new information. So 19 was complaint number 2025-000-551 and complaint number 2025-001921. So as that was presented back then, complainant alleged that a respondent had stalked himself and his girlfriend and abandoned a work vehicle with a decedent in the back of the van. Complainant stated that respondent was ultimately arrested and charged with stalking and evading arrest. Respondent admitted to being in a funeral home vehicle that the night he was arrested when stopping by complainant's residence. Respondent was ultimately terminated from his employment at respondent establishment. Respondent admitted that there was a decedent in the vehicle at the time he stopped at complainant's residence. Following respondent's arrest, the work vehicle with the decedent was transported back to the funeral home by a coworker, and the decedent was placed in the cooler. Respondent stated that the decedent was never out of his sight the entire time the issue occurred. Respondent pled guilty to the stalking charge, but provided documentation to show that the conviction had been expunged as of January 16, 2025. Respondent further admitted that a decedent was in the back of the work vehicle at the time he arrived at complainant's residence. This would qualify as a violation of professional conduct for both professional licenses, funeral director and embalmer. Stalking conviction was not a felony, nor is it considered a crime of moral turpitude involving fraud or dishonesty, and as such, respondent was not required to notify the board of its stalking conviction pursuant to Rule 0660-01-0.03I. The legal's recommendation was $750 civil penalty for both, and the board decided to do a $2,000 civil penalty assessed as a $1,000 civil penalty against the funeral director's license and $1,000 against the embalmer's license. So the update here. So legal has a few updates on this matter. Wanted to present it to the board and put it on the record. This additional information may or may not change the board's original determination, but legal wanted to be sure the board was made aware of the update. So regarding respondent's expungement, the expungement was for a separate charge stemming from the same events in August of 2024. Due to the nature of the expungement, I'm unable to provide any information on that charge, but ultimately it was nollied, which is what they call failure to prosecute, by the DA and was ultimately not pursued. However, respondent does still have an outstanding stalking conviction stemming from these events that has not been expunged, and that is that mistake on the original one is 100% my fault. I received the documentation, did not realize there had been a separate charge. So no one trying to mislead anyone. That's just on me. That's my fault. Based on the police report, funeral establishment, and respondent, this appears to be the timeline. On August 10th at 9 p.m., the respondent picks up the decedent. At 10 p.m., the respondent arrives at the complainant's residence to see if their ex-girlfriend was present. On August 11th in the early morning hours at 12:34, an officer arrives on the scene in regard to a, quote, suspicious individual behind complainant's residence. Near or around this time, while the officer was speaking with complainant, another officer located respondent at the front office building, and respondent fled on foot. Respondent disappeared around the bush line, and officers were unable to find them at this time. At 2:32 a.m., officers made contact with the respondent, detained him at this time, and ultimately took him into custody. Respondent stated that upon being detained, they were questioned for about 30 to 45 minutes. Respondent stated right upon initial questioning, respondent explained there was a decedent in the van, and the police made a call to the funeral establishment for the on-call employee to come pick up the vehicle. Respondent is unsure exactly what time the police made the call to the on-call employee, whether that occurred at the beginning of his detainment or after he had been taken into custody. At 3:51 a.m., an on-call employee with the funeral establishment arrives to take possession of the vehicle left by respondent. And respondent maintained that he was never far away from the vehicle and that the work vehicle was, at his farthest point from it, 100 to 150 yards away. Respondent stated it was a flat area and he was always within eyeshot of the vehicle. And so, again, I've just recommended this one for board discussion. I'm sure there may be questions. Like I said, if the board feels their previous determination is fine, you can stick with that. You can go higher if it changes anything. That's all up to the board.
So is there another complaint? Or just
So
you've opened another complaint? on
So
this?
the complainant opened two additional.
Same complainant as the previous one, correct?
Correct. Yes.
Girl-
Just
the ex-girlfriend.
basically saying, hey, there was more information the board wasn't made aware of. I'm going to file I think he filed the complaint on the funeral director's license, and then We opened one on the Embalmer for completion.
Okay, so you want to go first, Tim, or you want me to go first?
Go ahead.
Okay. Because I remember this one, because we talked about this one pretty detailed when we so now we have a timeline that does explain things a little bit further. So from the time he picked up the decedent at 9:00 p.m., 3.5 hours later, the first officer arrives on this scene to this situation, to 2:32, which is 2 more hours, so that's 5.5 hours, that this deceased person is in this vehicle at this location, correct?
Correct.
And I don't. With this timeline, that does change, in my opinion, from just a civil penalty situation. I mean, this person's a licensed funeral director, a licensed embalmer, that works for a licensed establishment that's been called upon to do his job, correct? We as licensed funeral directors and licensed embalmers and establishments have an oath, a obligation as the licensee in this state to treat the decedent with dignity and respect, which was obviously not done here, in my opinion, if they're sitting in a van for that amount of time while this person stalks his ex-girlfriend. Then also, essentially, try to evade arrest to get away from the police.
I don't believe he would have come back then and got caught.
You what?
I don't believe he would have come back with that excuse if they hadn't caught him.
Right, right. And the one thing that I don't think, I can't remember from last time, if we ever established, if this establishment notified the family of this person that this went on while they were in their custody, but they had custody of those remains, that person's remains. That's one thing that I don't know that we ever established. I'd like to think that if I was in this situation, that I would have called the family and said, "This is what happened. My employee's done this. I'm sorry. You know, we'll do what we can do to make it right. Or if you want to go somewhere else, we understand." You know. But the fact that he or she, I think it's a he, literally just left this person essentially sitting in a van in a vehicle for, by the time they 3:51, so almost 6 hours, 7 hours. I move that we change this to a suspension of licenses. I don't know what the motion needs to be in order to put that, but I'm not okay with that, and I don't think a civil penalty is something that is going to make a difference. It's obviously, a lot more information than we have now, that we didn't have before. And I'm willing to shape the motion however it needs to be shaped, but I think that is, in this case, is something that is absolutely necessary, and I feel that we would not be doing our due diligence as a board if we didn't act upon this with this other information.
And I agree completely with Mr. Nash. I guess to know that someone has been placed in a vehicle at 9 o'clock and at 3:51 that person is sitting evidently in a parking lot in the back of that vehicle when should have been already at the funeral home taken care of. I know if it was my family, my mom, spouse, child, or whatever, this would not sit well with me. And to me, there is a liability that lies with the establishment. We all are in business. We all hire people to work for us. And one of the things, and I agree with Mr. Nash, ethics. We have an obligation, a responsibility, and our ethics to take care of our families. When that first call comes in that someone has passed away, they are entrusting us with one of the most prized, valuable things they have in their life, and for it to lay in the back of a van And I have a lot of problems with the respondent stating that he was 100 to 150 yards away, but yet he was detained by the police. I question how he saw a van when he's detained by the police, and that loved one is sitting in the back of an unattended van. So I agree with Mr. Nash. I'll second his motion for revocation of both licenses with the state.
Are we talking suspension or revocation?
Let me, gentlemen, if you give me 1 second. Will this be a new case, or are we going to be changing the case from the last meeting first, how this needs to
So the board can do either. The board can just say, okay, for the two new ones filed, we appreciate the new information. We can close those and we can update our previous determination on those two cases. Or the board can say, okay, we appreciate the new information. I can do what's called a consolidated consent order where I put all four. I think functionally it's kind of, 12 versus a dozen. I think it makes probably more sense just to update the previous determination, close the two new ones, and then I can send an updated consent order.
My question would be that the former complaint, if we update that, we need the timeline and things are not in that complaint.
So I would, since the determination's being updated, the consent order would contain that information. I'll readjust the consent order from there. And then, so it should be able to proceed just fine in that sense. But again, if it gives the board more solace just to, new information was added in these two, we should keep these two and lump them together. That's also perfectly fine.
I think they need to be lumped together so we have all the information and the complaints.
So,
I don't, does that need to be a motion to do
correct me
that?
if I'm not right. Right now, the previous two cases, it was $1,000 on his funeral director. No, we
1,000
changed it.
1,000 each.
He had 750, we changed it. Okay. It was $1,000 per license. So I think the motion would be to amend that finding with the suspension or revocation and the time period, and then we'll consider the two new cases after that in the second motion to dismiss. So what we're gonna need a motion on now is to update, if you look at number 19 and 20, where it says 2025-551 and 1921, those are the correct ones, aren't they, Mr. Bryant?
Correct.
Those are the two that we're gonna make a motion to update. So let's do that first.
And just, excuse me, sorry, just 19 and 20. 21's a separate one, but
19 and 20.
Can I get a clarification real quick? Because I know Mr. Nash said suspension, I said revocation. So here's my question to the board. If we just suspend for 30 days, 45 days, 60 days, he automatically becomes licensed back at that point when the time period expires. Is that correct? Whereas revocation, we would revoke his license, and he would have to appear back before the board, showing that he has corrected this behavior. My greatest concern is, and I don't know his age or anything like that, but I take it he's a younger individual. And I'll be honest with you, I would hate to know that this behavior continues and he goes back to work for another establishment and this happens again. Evidently, there's issues in his personal life that he needs to deal with. And I agree with Mr. Nash. We have an obligation as a board to make sure that we have the best individuals possible licensed in this state to serve our families that choose those establishments. And there's where my issues lies on suspension and revocation.
Let me clarify, I didn't get finished just a minute ago, Mr. Bryant. I wasn't referring to cases 19 and 21. The end of them, the complaint on the Embalmers license was 1921.
19 and 20.
No, I'm talking about the actual complaint.
Yes,
Okay.
yeah, I see
There
what
you
you're
go.
saying. I'm with you.
The complaint number's on 19 and 20. The last four numbers, 19 and 21. I'm sorry.
Gotcha,
You follow
gotcha,
me?
sorry.
Okay.
Yeah, now I'm with you.
All right. All right.
Sorry about that.
But no, we're good. I just want to make sure that was clarified.
Did this licensee, they didn't pay the penalties that were assessed, correct?
So I spoke to them, and they actually reached out to me and just said, "Hey, what do I need to do?" I was aware that these two were coming, so what I didn't want to have happen is us get them, have to send them back. So I said, let's take care of these. I'll touch base. So he has not, but because of me more than him.
So, okay.
I think you gentlemen can ask for a suspension for a certain time period, and part of the remedy could be so many hours of ethics between now and then, and even to appear before the board at the end of the 6
Yeah.
months. And
That was going to be my suggestion, is that also, 'cause, at the end of the day, if what the board decides and what I put into a consent order, if they agree to it, then so you can feel free to get creative and do things like requiring ethics hours and that. So the way that would function is, let's say the board decided to do 6 month suspension, year suspension, whatever it happens to be, and 5 hours of ethics. When that time frame is up, when that clock ticks and, okay, your suspension's done, your ethics aren't, they are not renewed. They've got to check every single box that's in that consent order.
So is it my understanding there is still a stalking charge out against him that has not been expunged?
My understanding is that it is a conviction, yes. It has not been expunged. The other one was nollied.
It's stalking, it's not aggravated stalking, correct?
Correct.
So it's not a
That's my
felony.
Just
understanding.
plain stalking?
It's a misdemeanor, not a felony.
Yes.
Yes.
Okay.
Does the motion need to be that we take care of the complaints first, the combining or whatever we're doing first?
So I think, sorry, Mr. Elliott, I didn't mean to cut you off. I think what might be simplest, just so they're all together and it doesn't bog you guys down, just whatever you all want to do, I'll lump all four of them together, whatever the board decides, and then we can just have all four together under one heading. I'll send a new consent order.
Okay. My motion is that we suspend this person's funeral director and embalmer's license for a period of 12 months and require 5 hours of in-person continuing education with in ethics and 5 hours of or proof of some sort of that he's fulfilled his obligations as far as whether it's probation or whatever the is taking place with the criminal side of things. Just proof that he's fulfilled whatever the judge ordered him to do. However we need to word that. And authorization for a formal hearing.
so I guess, Mr. Bryant, discussion would be suspension of funeral director and embalmer's license for 12 months, plus proof of 5 hours of ethics, and represent to this board the outcome of the charge against him.
Correct.
Now,
So one thing I would recommend is well, I don't want to step on your toes. That's not what the suggestion is. But if it ends up being a represent, then once we get everything, then I think that could bog down resolution of it. What I'm happy to do is I'm happy to put that in the consent order of suspension of both licenses for a year period, require 5 persons of continuing education and ethics, and then I have proof that any obligations on the criminal side have been fulfilled. So that'll be in the consent order, and that'll be on him to provide that. I'm also happy to touch base with the criminal court and see were there things he was required to do, have those been fulfilled. That way, we'll prevent it from having to come back in front of you all, but we can still make sure that those things are provided.
Would it be appropriate to have him appear before the board?
I
Go ahead.
I'm gonna ask a question for us. So, Mr. Gribble, in those situations, when that person reapplies, they historically would have to come before the board or not?
Well, let me answer the question with a question.
Okay.
Whatever you decide in your consent order, and Mr. Bryan includes all that, then if he appears before the board, what authority do you have not to reinstate his license? Because
Sure.
you know,
Sure.
for whatever period you decide, if you decide on civil penalty, ethics, fulfillment on the criminal side, whatever you decide, if at the end of the day, he has fulfilled all those, is there any reason not to reinstate?
I don't.
Now, you could make part of your consent order that he attend. Well, that's physically a problem for him
Okay,
because he's out of state
okay.
now.
So is he currently employed in the industry?
To our understanding, he is, but at a far distance from here. So attending a board member, that was one thing I was going to say, attending a board meeting, but then that's kind of like,
If he proves that he fulfills what we've asked for, I don't have an issue with him. I don't think that's necessary for him to appear before the board.
Because in his mind, if he does all this, he knows
Right.
we could still take it.
I do think that if he's licensed in another state, that they need to be made aware of it.
And they are. When this individual applied for that state licensure, every state does it a little differently, but my understanding is pretty much everyone reaches out to, hey, this person's licensed here, anything we should be aware of. We made them aware of this on the front end. And we're happy to, if this ends up in the respondent signing a consent order, we could send that over to the new state as well.
So I'll amend my second to Mr. Nash's motion. Since he is employed, I think a civil penalty lies in place also as a deterrent to not create this behavior to occur again. So I would almost say let's leave the original finding of the $1,000 per offense civil penalty, and then the year suspension of license, the 5 hours of ethics, and then to see where we stand with the criminal charge, if that's good with Mr. Nash.
Yeah, I think we're just adding on. The original $1,000 on each license has already been ordered by this board, correct?
Correct. And I mean, it would be up to your purview. I mean, you could, to Mr. Wheeler's point, leave that
Oh, I
2,000.
I thought it
Yes.
was left. That's what I
Okay.
want to make
Yeah,
sure.
I guess if you're going back and determining what do we do now, it's not necessarily still there, but you can, of course, still include it. So.
All right, Mr. Nash, you listen to all that.
I think so.
All right, hang on, let me catch up, and then I'll let you make your motion.
So the $2,000 is already handled. That's
No, that we're going to add it into this one, so I
Yes.
need
Okay.
you to amend
Okay,
your
so-
motion, adding, it's like a fresh start.
I'm in.
on that.
Okay, so I just need to. Okay, I amend and make a motion that we keep the $2,000 civil penalty of $1,000 per license, and add revocation of funeral director and embalmer's license for a period of 12 months, and the licensee may reapply once they have, or license may be reinstated once they have proved they have had 5 in-person continuing education hours regarding ethics and that they have fulfilled their obligations from the criminal case. Is that good?
That's good with me. Do we cover everything, Mr. Bryant?
Yes, sir.
Do I have a second? Mr.
Second.
Okay. Okay. Have a motion on the floor by Mr. Nash and a second by Mr. Wheeler. All in favor, respond by saying aye.
Aye.
Any opposed? Motion carries unanimously.
Yes. Okay. Last one is another represent from one presented back in February of this year. This is complaint 2025-001031. Complainant alleged that respondent had refused, to provide their siblings, the decedent, their final resting place by disregarding complainant as next of kin. Complainant also alleged that respondent had overcharged them for cremation. Respondent stated services were provided in August of 2023 and that respondent, quote, slandered and defamed, end quote, complainant after they, quote, found out their siblings were not placed in a vault immediately following funeral services, end quote. Respondent provided no further details or documentation. Respondent stated that primarily two separate individuals made arrangements for the two decedents' funerals and cremations as they were the designated family members responsible for logistics. Respondent stated it is their policy to only disclose information and engage in discussions involving arrangements with identified responsible parties, which did not include complainant. Excuse me. Respondent further clarified that the charges incurred were not only for cremation, but referred to for two funerals and subsequent burials. Respondent stated that the arrangements were expressly requested by the designated family members. Sorry. Apparently 20 complaints is my limit. But, Respondent stated that the arrangements were expressly requested by the designated family members and that all charges were disclosed and discussed prior to execution of services. Respondent stated there was a logistical delay in transporting the decedent's remains to the cemetery, but this occurred because the two designated family members had not signed an authorization form. Respondent stated that despite numerous attempts to reach the two designated family members, they failed to respond back in order to sign the authorization forms. As a result, they were forced to hold the remains until proper authorization was received. Respondent submitted a supplemented response stating, quote, the arrangements were legally authorized by another family member as substantiated by the attached authorization for cremation and disposition. The authorization, end quote. The authorization form identifies the authorizing family members as another sister of the decedent and a grandmother. Respondent also provided a written letter from one of the decedent's girlfriends and mother of the decedent's children. The girlfriend corroborated that the delay in transporting the decedent's remains to the cemetery occurred because, quote, no one was able to reach them, end quote. The girlfriend stated she assisted in respondent finally making contact to have the form signed. And so at that time, based on the above, it appeared that respondent had made reasonable efforts to receive the appropriate authorization form to have the decedent's remains buried at the designated cemetery. However, respondent had designated two family members as a legal next of kin, a sister and a grandmother, foregoing complainant, another sister of the decedent, as a next of kin determinant. Pursuant to applicable law, absent a power of attorney form, which respondent did not provide, a surviving sibling proceed to grandmother in order of next of kin determinants, and complainant's role as next of kin should not have been foregone in favor of the grandmother, and legal recommended a $750 civil penalty. It was sent for further investigation to receive the cremation authorization form for both decedents, determine when respondent learned there was another sibling, determine if there was a POA document, and the statement of funeral goods and services for both decedents. So just take them one at a time. POA, I spoke to respondent on all of these. Legal confirmed with respondent that there was no POA document that transferred power to the non-complainant sister and grandmother. Statement of funeral goods and services, they provided those documents for both decedents, consistent with the forms provided earlier. The non-complainant sister had signed for the sister decedent, and the grandmother had signed for the other decedent. For the cremation authorization forms, much of the same. Non-complainant sister had signed the authorization form for the decedent's sister, and the grandmother had signed for the other decedent. On the death certificates, it again was consistent with the non-complainant sister listed as the informant for the decedent's sister and the grandmother listed as the informant for the other decedent. Respondents stated they could not recall exactly where in the process of arrangements they first learned of complainant and their relationship as sister to the decedent. However, respondent also provided the following in one of their responses. Quote, we clarified that complainant was not the designated family representative who made arrangements for the brother decedent. The arrangements were legally authorized by another family member as substantiated by the attached authorization for cremation and disposition document. Our aim in highlighting this point is not to contest complainant's grief, but rather to provide clarity on the appropriate channels concerning the decisions made related to the decedent's funeral services. In closing, we seek to clarify that the issue raised by complainant stemmed from misunderstandings related to the funeral process, compounded by family dynamics outside of our purview, end quote. While legal can agree that certainly there appears to be family dynamics at play that the board and legal are not privy to, based on all the information provided, it appears clear that one of the two surviving sisters was made the person with the right of disposition for the sister who had passed away. Likewise, based on all the information provided, it appears clear that the grandmother was made the person with the right of disposition for complainant's brother who had passed away, leaving complainant, the other providing sister, without the right of disposition. While respondent may have their own processes and the two family members selected may have been selected by the family and given authorization, 62-5-703 is clear that the surviving sibling has priority over a surviving grandparent, right of disposition, and based on the information provided, complainant, a surviving sibling, does not appear to have waived that right of disposition at any time, and in fact expressed frustration with the fact that they were disregarded as next of kin. So based on all of that, we would recommend a $750 civil penalty, authorized via consent order, and a formal hearing if necessary.
On that represent, did that answer questions?
It did, yeah, absolutely. Mr. Bryant, we're going to get you some oxygen after this. Thank you for all that and for investigating this further. That's kind of what I assumed, but just thank you for the clarification. I make a motion we accept recommendation.
Motion on the floor by Mr. Nash, second by Mr. Wheeler to accept council's recommendation, $750 civil penalty and authorization via consent order and formal hearing if necessary. All in favor respond by saying aye. Aye. Any opposed? That it?
That concludes the legal report.
Thank you. Mr. Gribble, the executive director's report.
Good morning, board members. First is the legislative update. Of course, the first half of the session is adjourned, and the bills that were passed are still moving through a process. All of them may have not been signed a public chapter yet or action taken upon them, but most of them have. House Bill 0860, Senate Bill 1149 regarding funeral directors and embalmers. It's been assigned to Public Chapter 198, and we furnished that information to you. Basically, what that does, after July the 1st, 2025, it will allow people who are seeking a funeral director's license for it to only be necessary to serve 1 year apprenticeship, providing they have a associate degree from a mortuary college, or providing they have 30 semester hours of education from a mortuary college whose programs are accredited by the American Board of Funeral Service Education. So it reduces the apprenticeship time from, in the very common language, it reduces the apprenticeship time from 2 years to 1 year for funeral directors. And of course, it's always been 1 year for those embalmers who had an associate degree, or I say always, has been for a number of years anyway. House Bill 1237, Senate Bill 1235 has to do with boards and commissions. It's been assigned Public Chapter 294. That is a bill that affected a lot of boards, and we provided that for you. It just basically removes, says a person must not be excluded from membership on the board on the basis of race, color, ethnicity, or national origin. A person must not be subjected to discrimination on the basis of race, color, ethnicity, or national origin as a member of the board. That's one of the factors. There are many, but they're all similar to that. House Bill 1330, Senate Bill 1316. It's Less is More Act of 2025. It's passed, but as of late last week, there was not a public chapter assigned to it. I feel with certainty that the governor will sign this bill because it's an administration bill, and it makes some changes to the board in regarding reappointments to the board. And we should have a public chapter probably, once it's signed, probably have a public chapter before long. And then a bill that doesn't directly affect the board, but it affects funeral directors and the families that funeral directors serve, is House Bill 0713 and Senate Bill 0715 regarding cemeteries, and the public chapter 119 has been assigned to that. That changes the installation fees. the memorial care fees, eliminates a cap on the contract of $100. And Mr. Bryant, there may be some other changes to it, but those are basically some of the items in it. And that is effective January the 1st, 2026 is the effective date for that. Got a website there for the legislative bill searches, and also a website for you to find the public chapters. And we'll put these in the minutes and on the website so that people will have access to them and work to make a smooth transition into taking care of what we need to do on their end for those that directly affect us. Licenses issued, these are administratively approved by the executive director pursuant to board authority for the period of March 29, 2025 through May 5, 2025. You have a list of those before you. Also, disciplinary action reports, the report of consent orders have been administratively accepted or approved by the executive director pursuant to board authority, and those were reported on the March 2025 DAR disciplinary action report that's published to the regulatory board website. So you have a list of those individuals there, or the respondents, which in cases could be establishments or individuals, the location, the violation, and the action that the board took and they consented to. As far as complaints, as of May 6, we had 69 complaints. 39 of those were against funeral directors and embalmers, and 30 were against establishments. We have no closed establishments to report. As of this meeting, there are none that have closed since the last board meeting. That concludes my report. I'll be glad to answer whatever question you might have.
Any questions for Mr. Gribble? If not, I'll entertain a motion to accept the executive director's report.
So move.
Motion by Mr. Whaler,
Second.
second by
Yeah.
Mr.
second.
Nash. All in favor, respond by saying aye. Aye. Any opposed? Motion carries. Ms. Leitzer, Mr. Gribble, do we have any applicants that appear before the board? Any individuals?
There are no individuals. You do have 3 establishments. The first one is Choice Cremation. The proposed manager is Emily Crow. This is proposed location is 907 Rivergate Parkway, Suite A8 in Goodlettsville, Tennessee. It's an initial establishment application. The ownership would be a limited liability company owned by that LLC, Choice Cremation LLC. And as you may recall, these are applications that were before the board last month and were tabled until this meeting.
Thank you. Ladies, welcome back. Sorry you had to come back another month later. I'm going to kind of skip to Mr. Whaler, Mr. Nash, to see if maybe what they had asked be done has been taken care of, and hopefully we can get going from there.
I looked through everything yesterday, and everything we requested is here, and I make a motion, we approve the application.
Second.
Have a motion by Mr. Nash, a second by Mr. Wheeler, that we approve the establishment application. All in favor, respond by saying aye. Aye. Any opposed? Motion carried. Thank you again.
Congratulations.
Congratulations.
Thank you.
The next application is Scales Starks Funeral Service Incorporated. Proposed manager is A. Brandon Starks. To be proposed location is 810 Dominican Drive, Suite 302, Nashville, Tennessee. And the owner would be a for-profit corporation, Scales Starks Funeral Service Incorporated.
Thank you, sir. Welcome back. I'll move again to, I think part of that was it the sharing with, or
The
I can't
office
exactly
space.
remember.
The sharing of the conference room.
Has anything been updated on this, Mr. Gribble or Mr. Bryant, or anybody that can, of what was asked? Did y'all have to re-inspect or go back and look again, or are we any different than we were?
We did not do another inspection. Mr. Starks submitted documentation to the board that is included on your iPad.
So the concern was, the visitation and viewing rooms. That was the only thing that was discussed. I was just asked to submit pictures of the viewing
Yeah, it
rooms.
was the photographs of the establishments and the letters. That's what we asked for.
It was the same as, right, it was, all three of us had the same issues. The board wanted pictures of the viewing rooms.
But if I'm not mistaken, we did bring up the issue of sharing of the conference room because it is in a facility that you stated you had to share, and you have to reserve the conference room. Is that correct?
That is correct, but the majority of my conferences are held in my office. It's more than enough room to have conferences in the office. I very seldom would use the conference room. I do a lot of arrangements at the residence as well. I find that most people prefer to do arrangements at the residence. I did that a lot when I actually operated Scales Funeral Home on Jefferson Street.
So I guess my question lies because appearing back today, the whole application we look at, it's not just, we did bring up issues last month, but we today look at the whole application again. It's for review. So I guess one of my major questions is because like where I'm employed, while we might have scheduled families, we have what we call walk-in families. They've had a death, they leave the hospital, they come right to us, or the death has occurred in a facility. And I guess I'm questioning how those families would be taken care of.
They would come to the facility and be
Well, I mean, they just walk in. A walk-in family means they just walk in the
right, so I'm
facility
saying that they would
unannounced.
walk in, the receptionist would greet them, and they would be escorted to my personal office, and they would be seen in my office.
So my question is, what if you have another family there?
If I had another family there, I could still make arrangements to meet with them. That would be no different if I were meeting with the family at the facility I previously had. If I were meeting with the family and another family walked in, it would be the same scenario. So the receptionist would meet with them to discuss the nature and find out all of the particulars until I was able to meet with them or schedule a conference with them or get the other funeral director on call there to meet with them.
I guess my question lies, and we just heard a case earlier where a funeral director, let his license or her license expire. A family walked in, they were adamant they wanted waited on. That person waited on him and violated state law of waiting on a family because their license was expired, and they stated that the family was just adamant they were going to be waited on. So there I question not having enough facility to handle
Not having
the
enough
need.
facility or not having enough staff. So there have been instances if someone comes in and if I'm operating with an establishment, I only have a limited number of funeral directors and I can't serve them, I simply can't serve them.
So you would turn business away?
I have turned business away. All business is not good business. I've had instances where if I can't serve someone, I simply can't serve them. There have been instances where someone wanted me to provide them with something that I simply could not provide them with. I'm not going to overextend myself, but at the same time, if someone is asking me to provide them with something that I know fully well I can't provide them with, I'm not going to tell someone that I can provide them with something that I know fully well I can't provide them with. So rather than putting my name and reputation on the line, making an assurance that I know for certain that I can provide something that I cannot, I would rather them go somewhere else where they can be better served.
Mr. Bryant, is there anything in the state law on establishment about having dedicated space for arrangements?
Yes. So in rule in 0660-06-.02 regarding fixed place of business, section 1 there says an establishment shall not be operated and no establishment license shall be granted or renewed unless the applicant has a fixed place of business or establishment that is devoted to the care and preparation of dead human bodies. Section 2 states, the board, in determining whether an applicant's proposed fixed place of business or establishment is devoted to the care and preparation of dead human bodies, may consider factors including but not limited to. And then I think there, B is most relevant. Any evidence at the proposed place of business that suggests activity other than incidental to the care and preparation of dead human bodies. So if you've got a situation like this where you have a larger building where there are other businesses and things going on, those common areas where it seems like here there would be a conference room that could be used by the establishment, but also booked and reserved by other businesses, that could be something to that the board may consider as a potential issue arise with fixed place of business.
But at the same time, there are multiple conference rooms available within the building. So I wouldn't be just limited to the particular conference room on the floor that I'm on.
And sorry, also, I think D may be relevant as well. If the establishment is located within a business complex, whether the establishment is clearly separated from any other entity located within the complex and clearly distinguished by professional signage.
Okay. Thank you, Mr. Bryant.
Mr. Gribble, do you know of any establishments that are currently operating that in a similar way of what Mr. Starks is proposing as far as having a dedicated office for their business, but then a shared conference area?
There may be. Mr. Stark says he's aware of one. I am not, but there may be.
Randy, I'm Steve Murphy. Of course, you know me with Music City Mortuary.
Yes, sir.
We provide those exact same services for Austin Funeral Service and Cremation. Their setup is identical to Mr. Stark's.
In, you said Austin in Brentwood?
Brentwood, yes.
Mr. Murphy, do they, and I've never been there, so I don't know, and they were approved prior to me coming before, or at least my memory is they were approved prior to my employment. But again, I've forgotten over the years. Is is there only one office? There are no more rooms when you walk in that complex? Is there only one office
Yeah,
where they are?
yeah, they have their office, which is completely walled in, and then they have a shared conference room that they can use. But it's my understanding they do most of the arrangements there in their office, but they do have access to a conference room if they choose to use it.
But the conference room is in another location.
It's in the same building, but it's one of those you would have to schedule, like Brandon would have to schedule.
But I mean, it's like it's separate from their
Yes,
office. It's
it
not
is.
adjacent.
Yeah, you'd walk out into a hallway and go to
You
it.
can go to it, yeah.
Yes.
Okay. Thank you, Mr. Murphy.
Yes, sir, thank you.
Since he mentioned her name, I didn't mention her name previously when I was here before because I didn't discuss with her in terms of mentioning her name. But prior to doing this, several years ago, I had extensive conversation with Ms. Austin before I decided to do this, and then spoke with her again just prior to doing this. And from what she shared with me, because I had reservations simply because my first exposure to funeral service was with a full-service funeral home, and I had some reservations just wondering how exactly it would work because I had never been exposed to it before, and she just reassured me that she just did not have any problems in operating like that. It's a matter of logistics, scheduling, and being organized. And she just kind of reassured me that being familiar with me as a funeral director and with my reputation, the caliber of clientele that I served, that she didn't foresee me having any problem, as she had not.
Do you, how many, what was your call volume at your previous, when you operated your previous funeral
So
home?
we did about 50 to 60 calls per year, and my volume had started to decline. The last couple of years I was in business, the building needed extensive renovation. We had issues with the property owner in terms of renewing the lease. That was one of the reasons why we closed, because we were operating without a lease. So it dropped down to about 30 calls per year, the last 2 years.
Do you anticipate it being a relatively similar call volume in this?
That or maybe even lower, because again, I'm just
Sure.
getting started back.
Sure. I make a motion, we approve this application.
We have a motion by Mr. Nash to approve the application. Is there a second?
I'm going to add something here that it is,
Is it on your motion?
no, I'm sorry, I'll be.
No. I guess we need a second on the motion to further discussion before a vote. Mr. Nash, do you want to withdraw your motion at this point? Since we don't have a second, let's have discussion and see what.
Sure, I'll
where we're at.
I'll withdraw the motion if we want to discuss.
All right. Go ahead and add what, or ask what you were asking.
So I think, being that a establishment of this type has been approved in the past, that, and being that, you know, you've been a licensed funeral director for how many years?
34 years.
34 years. I have faith that you can schedule things to the best of your ability. We all know that there's going to be unforeseen situations that
Right.
pop up. Happens every day in any kind of industry. I think it's just it's a different business model than, I mean, I get it. You're not in a traditional, you're going from a traditional funeral home to a different business model, so it's going to
Right.
change things a little bit. And so I think it's just going to require some adapting and some scheduling on your part.
Right.
But I feel like you understand that, and I don't. I do have a little bit of reservation with the shared space, but I know if it's been done previously, and you know, our predecessors approved an establishment for licensure with that. I feel that we are obligated in this case to do it as well.
I will say this, once I had the understanding with the property owners that I can use any of the conference rooms in the building when they said they require prior
So there's
notice.
multiple rooms?
Right, each floor
Okay.
has a conference room. I was
Okay.
okay with that, because one of the things I actually thought about was that I would actually prefer the conference room on the first floor may be better.
Sure.
In terms, you know, if I were going to have a large number of people. I have a tendency not to prefer an extremely large number of people in a
I don't think any of us do.
Right. So for me to see six or seven people in my office is not a problem, but I would prefer not to have a conference that large.
I guess my greatest concern is I go back to Mr. Bryant with the law as it now states. What might have been approved 30 years ago, 45 years ago, whatever, because just like when I went to mortuary school, there was very few laws with the state of Tennessee for me to get my license. Things have changed, And I think we need to abide by the way the law is. My greatest concern is to allow something like this. The next things we know, we might have someone wanting to locate in Sam's Wholesale, Costco, the Walmart. And I'm not sure that is doing the industry a service. And I feel Mr. Bryant has expressed through Tennessee Annotated Code, and I just don't feel comfortable approving it at this point.
So I will say this, the ladies that just left, we were actually in a continuing education class previously at the Middle Tennessee State Veterans Cemetery. And from what I understand, they have the exact same setup. We had just discussed that about 3 weeks ago at a continuing education session. So they have the exact, very similar setup, meaning they have an office space and then they also use a conference room.
Mr. Nash, I appreciate what you said. I think we all have our own feelings about storefronts. It takes the tradition out of funeral service, but anytime we have them before us, always ask that they meet the requirements that are on the book. Until we or somebody changes the law, I think it is what it is. So, Ms. Nash, if you want to make your motion again or go from there.
I make a motion to approve the establishment application.
Have a motion on the floor by Mr. Nash, a second by Mr. Haynes. All in favor respond by saying aye.
Aye.
Any opposed?
No.
Have one no. The ayes carry. Congratulations, sir.
Thank you.
Congratulations.
And I'm
Trust me, I
sure
will
you'll get
not
with Mr. Gribble and Ms. Lisa
Okay.
and make sure everything's good to go.
do my
Okay.
best not to let you gentlemen down. My good name and reputation, as well as my license, on the line as well. Thank you.
Last one, Mr. Gribble, I believe.
Yes, there is one more.
Stevens Funeral and Cremation Services.
Stevens Funeral and Cremation Services proposed manager Philip Charlin to be proposed location 105 Southeast Parkway, Suite 110, Franklin, Tennessee. It's an initial establishment, ownership, a limited liability company, and the owner Stevens Funeral and Cremation Services LLC.
Thank you, gentlemen, for coming back. Yes, sir. Ms. Nash, Mr. Whaler, I believe, was this the viewing as well? I'm sorry, I don't remember.
Yeah, I think that everything.
It was viewing, and I think the phone number and stuff like that, and from, looks like all documents submitted, they've filled the request of the board.
Yeah, I make a motion to approve this one as well.
Have a motion by Mr. Nash for approval. Do we have a second?
I'll second.
Second by Mr. Whaler. All in favor respond by saying aye.
Aye.
Any opposed? Thank you.
Thank you, John. Thank you.
Congratulations.
Thank you.
Mr. Gribble, are we, would you be handling new business, I assume, with the stuff they rulemaking hearing?
Mr. Bryant may want to speak to that. Either one of us can, but he's better qualified than I am.
Yes, so, yeah, exactly. Had a little bit of a rest, but so if you all remember, I guess it was, we originally brought rules to the board almost a year ago at this point. There were a couple things that ended up needed to come back, so we came back, I think, either at the August or September meeting of last year. Those rules have progressed well. They're up to the next point, which is where we do a rulemaking hearing. Essentially what it is nothing's changed substantively since the board had their initial review on them. The board will vote whether to essentially send them on to the Attorney General's office to check for constitutionality, things of that nature. If you recall, I would say, I think in funeral, all of those were more kind of administrative in nature in regards to the retrospective review, which every certain amount of years, every agency is required just to look back at their rules, say what's still working, what isn't, what's obsolete, what can we update, things of that nature. So primarily administrative in nature. Those will come forward at the next board meeting where anyone who would like to make public comment is more than welcome to do so. And then at the end of that, once I read through all of them and everything, the board will vote whether to move those on to the next step of the process. So I guess, Ed, if you have any questions on that, generally speaking, I'm happy to answer anything I can. And, if there are questions next month at the meeting regarding it, you can always ask me then at that time also.
And for the benefit of those that might be watching during the next few days or few weeks, if they'll go to today's agenda on the board website, then there's a link there to the notice of the rulemaking hearing and also a link to the copy of the rules that are going to be considered. So that way they'll know ahead of time exactly what the board will be considering at the June 10th meeting as far as rulemaking.
Will that will coincide with our June board meeting?
Yes, sir. The rulemaking hearing will occur first.
Yes. If you thought I talked a lot today, then next month you'll hear a lot from me.
Do we have any further new business to come before the board? Mr. Batson, I would like to welcome you. Anything TFDA, you're all good.
Appreciate the offer.
All good, I'm assuming.
Mike's not on.
I apologize. We have no further new business. I'll entertain a motion to adjourn.
Public comments.
Sorry, I cut off my second page. Do
And
we-
also, if there might be someone on Teams that wants to make a public comment, I've been reminded for you to ask about that as well, please.
Thank you. Do we have any public comments?
There's no one who signed up to make public comments, and there's no one on Teams as well.
Thank you for taking care of me as always, Miss Lisa. Now, I'll entertain a motion to adjourn.
So moved.
Please second this one.
Second.
All in favor, respond by saying aye.
Aye.
Meeting adjourned.